3985 should come back up now.
So you had 2000 Patrick Spalding.
10-4. I think it's from northern something like that. I might not be leaving it over. My vehicle is I can remove it.
Rockingham 505. 505 engine vandalism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive this at 32.
10-4. 532, you're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. No, 3 in Depot Street. Truck boy entry 5.
7435.
10-4.
10-4.
Can you go to 43 again?
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4, I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
And 449 1121, thank you.
10-4.
Code 4. 4.
Rockingham 535.
Yeah, that's a great college.
535.
Should be. You guys know what our woman who fucked into a house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get in still. About 5 foot, long dark hair, got tie-dye shirt on, and number 21 phone.
We have separation. Inboard now. Excuse me. All right. Good morning, everyone. Trying to get all my shit together. Got making sure all the computers are up and running. so I can log into whatever is giving us the clearest and most consistent picture. So bear with me a second. Still got one more to log into. All right, good. I think I'm into all three. All right, good morning, everybody. Just was here last night, so not a whole lot to talk about, but we got a big trial, big hearing coming up today. So let's see. I guess let's just jump to your thoughts and see what's going on, because I don't have anything new to talk about. Obviously, today's going to be just a long day because we'll be discussing the motion to dismiss. This is the defense's motion to dismiss, and then the rebuttal to that by the state. We think we're going to finish up probably right at the start of the outset with the ARCA stuff. Perhaps more questions from the judge to the defense team in particular. That seems to be a continuation of last Tuesday's hearing, but I'm not sure. Last Tuesday's hearing also seemed to kind of wrap up, but there's been no announcements by the judge, so I don't know. Could be plenty of dramatics today, some fireworks, but then again, who knows? And, you know, I don't know which defense lawyer is going to argue about the motions, but if it's a lessee, we're in for a long day. You know, it is what it is. Just looking at chat. Good morning, Jules, Francesca, Bev Murphy. Thank you. Nunya wants to know who the Patriots are drafting at 4. I'm hoping Travis Hunter, but we'll see if he's available. So I asked anonymous email the other day. Anonymous email. She's anonymous mass lawyer the other day. If he thought it was a possible solution that Judge Cannoni will not remove any of the attorneys here, but instead her solution will be to not allow the defense team to present these the ARCA experts as independent. In other words, to not even discuss how they became involved in the case and how they were hired. And so I don't think I'd be violating anything to Okay, so I just got a message from Kate that she has an appointment with a dog groomer. So she's going to try to jump on later. And I don't think Jen will be here either. So I haven't heard from Matt from Boundless Millennial, so I don't know. And I also don't know about Daniel. He comes on when he can, but he has medical stuff going on Tuesdays related to his dog bite. So what I had asked the anonymous lawyer, we've all been enjoying his or her excellent articles, could Judge Cannoni instruct the defense that they can no longer refer sorry, my usual morning thing. You got to deal with it. I got to deal with it. So I asked him if the judge could say how the ARCA guys could no longer say how the ARCA guys came to be involved in the case, and instruct them to stop using the word independent. And so this was what his answer was. She has some latitude in this area, as we saw in the first trial when she didn't allow the defense to inform the jury that these experts were originally hired by the feds because she deemed that information to be more prejudicial than probative. That said, I don't think she'll go as far as entirely forbidding the defense from explaining how ARCA came to be involved in this case. While we now know that their independence was a little overstated, it remains true that they were originally hired by and submitted their conclusions to a third party, the U.S. Attorney, the feds. I think that's relevant information to the jury, and she won't want to withhold that from them and risk being ruled in error on appeal. I think she'll probably handle them in the second trial the same way she did in the first trial, to the extent that the defense doesn't on their own make the record clear about payments and interactions, so certainly allow the prosecution to cross-examine them on the issues. So what I replied this morning was, I agree with your reasoning. However, I wonder if the door is more open to her to do this because of the Fed's refusal to comply with Rule 14 discovery regarding the messages involved in the hiring of ARCA and the instructions they gave him. This is Hank's basis for having the ARCA guys removed from the defense expert list. So the judge might say, I don't want to take this tool, ARCA, out of the hands of the defense, but since we don't have the messages surrounding their hiring, then let's just forbid anyone from talking about it. So no claims of another entity that hired them or no claims of independent experts. Just go to these experts and ask them what their opinion is based on the evidence they had. And that's it. I think that possibly could be the fairest solution here. And at this point, those ARCA guys should have the full evidence sent to them by the prosecution and no excuse. So that's my common sense bartender approach to doing things, which is not always going to be the same as the way it's done in court, because I'm not a lawyer. Ama, that's an interesting name. Ama, thank you very much, Ama. Appreciate it. Cheryl Ann, thank you very much. Very generous. Thank you. You guys are very nice to me, and I appreciate it. We have a new member. I think if that's Allie or Al in the 90211. Is that out in California? Welcome. And Tolly says, I hope you're feeling okay, Kevin. Any update on the book? Thank you always. I mean, the target date for the book is still April 1st. The publisher's dealing with some of their own his own health issues. And it should be up for pre-order by now, but it's not. So I don't know. This publisher has been kind of a very rocky road for me. So we'll see what happens. Potluck, member for 5 months, says, hope Hank kicks it today. I mean, I think that the secret to Hank's success is not going in there, and I don't think this is his style, and trying to be Alan Jackson, trying to be Tom Cruise. I think the key to his success is just being extremely thorough and diligent in all the preparations and all the motions and everything they do with the evidence. And it's just kind of like a tide that keeps on coming. You can't really stop it. And I think that's the key. I don't think he has to go up there and always be brilliant, be a brilliant orator. Now, maybe he can. I'm not saying he can't. We'll see that during the trial. But he doesn't need to be. And there's a value. I think even Adam Lally, had they just given him the resources to bring in some independent experts, and had he maybe had a little bit better strategy, I think he would have done a good job. Yes, his delivery is dry, just a facts man, but there's an advantage in that. You know, I think juries trust that. They're like, here's a guy that's just doing his job. He's not trying to make a name for himself. He's just a diligent employee that's trying to do the best he can. So I think I think there was an advantage to Adam Lowry's style juxtaposed next to the defense style. Not just Alan Jackson, but even David Yannetti. And some of that is maybe you're going to always see more flamboyance with defense lawyers. It just kind of goes with the territory because they're trying to create doubt. They're trying to attack witnesses and investigators, whereas the prosecution is really supposed to be just the truth, just the facts, ma'am, and you guys figure it out. All right, how you guys doing this morning? Hey, Stephen, good to see you. Joe, thanks for being here. Allie, I hope the trial starts on April 1st, too. I think maybe most of us, from our own personal point of view, want this to be over. But in addition to that, it really is. It's important for the O'Keefe family and for the witnesses here to just so they can move on with their lives. But I think most of us, maybe, well, obviously with the exception of Karen, just want to move on here. Good morning. Work? You mean they haven't suspended all work in this state while this is going on? Thank you, Laurie. Good morning. The jury selection will take a long time. It would seem so, right? But it didn't last time, so I don't know. But I think they're going to be more cautious this time, so I think you're right. Kim, good morning. Kim Cradu. Ashley might be listening on the way to meet with the oncologists. If you are, good luck with everything today. Good morning, Don. So I'm sorry I don't have anything much to talk about this morning. We've kind of talked ourselves out on this case. All right, so I'm already seeing the notification for the trial. So at least for the hearing. Let me put this in so you guys can see it. Now that's Law and Crime. I'm going to probably go to Court TV's coverage because the audio was always a little bit better. But we'll leave the Law and Crime one on for now. The Court TV one. Oh, good. They already have the notification up. Or maybe not. The Court TV feed is about 20 seconds behind the live feed. which really isn't a big deal, but the volume is better. Looks like they're showing a commercial. There's a new series on Court TV. I don't know if it's a series or a single episode on the OJ trial. So, I mean, you know, here was a case, the OJ trial, where there was a mountain of evidence against OJ, you know, just indisputable evidence that he killed these two people. But was there possible police misconduct? You know, I don't know. And I think there were 3 primary investigators assigned to it. And the 2 senior detectives had an unblemished record. But the Los Angeles police was kind of on trial at that time because of the Rodney King riots. So just there was a lot of general mistrust of the police. And then Mark Furman had done some interviews where he did some I don't know, he was helping somebody to do a screenplay or something like that. And he used the N-word. And so once that was exposed in trial, that just fueled the idea that these cops might be framing O.J. Simpson. And so the prosecutors made some decisions to try to, they decided to try to avoid any evidence that the defense could argue was planted or somehow tainted by a racist police force. But that was a huge part of the evidence. Because, for instance, they had blood. The OJ's blood was found at the crime scene, and Ron and Nicole's blood was found both in OJ's Ford Bronco and in his house. And they couldn't use that. There was other evidence too. I mean, it was just really bulletproof kind of evidence. So I'm told the Glairer kind of lives up here now. He's shacking up with some FKR girlfriend. So great. Thank you, Karen. You brought that guy to the state. Jesus. Tennessee, you owe us because we took him off your hands for now. You owe us, Tennessee. Good morning, Thomas Fleming. Matt Hurd says, this entire case makes me lose faith in humanity. I understand the feeling. I would say a little less strongly than that, but there are definitely frustration that I worry that people can, even if presented in the full logic of this case, just reject it and go with butt dials and ghosts. I don't get it. It is a little scary to me. Now, it's a little different, say, the people that are just focused on reasonable doubt or maybe thinking the investigation was sloppy. And I don't necessarily agree with any of those things. But for people that are actually going around and saying that the evidence against Karen is weak, or going around and saying that there's a conspiracy, it's just crazy. It's hard to really, it's very, very hard to be respectful. Because if you know all the evidence, it's just hard to still imagine that you would still think that. Mayo, I'm sorry, that's Maya. My eyes aren't too good at the mornings. Maya from Norway. So this is we also have Marius from Norway. Marius has actually become a friend, and he talks to me on Facebook. and he shares his thoughts on the case. He's a very tech kind of guy. He knows a lot about tech, so he's been very helpful. Jenny, I had more scans Saturday, and I don't meet with the oncologist till Friday to find out what the plan of attack is. So, but I'm feeling pretty optimistic about having a good chance in the fight. So, KC is in the UK. We definitely have several people from the UK. We've had Nima and a couple others from Sweden. During the trial, we had someone from Finland. Not sure if she's still around. We had a guy from Germany during the trial a lot too. Not sure if he'd probably be back during the trial. And I don't think we've ever had anybody from Russia. No, Andy, that was just, I revealed that last Tuesday just because I had gotten my most recent scans, and there was disease progression on T9 and T10 on the spine. And, so slow moving at this point. So I'm hoping that when I meet with the doctor, the plan will be to radiate it. So you go do a week's worth of radiation. I think because of the time that I've been on the therapy, it's at the outer edges of where it'll work. It generally only works for a couple of years, and I've been fortunate to get 6.5. That they may explore other options, such as like clinical trials, or there's been some studies that you can boost this drug a little bit with chemo too. So I don't know. We'll see what they say, but I'm ready to fight. Bucks and 6 is back. Top of the morning. I don't know. Your Bucks. They had a run this year where they looked pretty good, and now it's looking kind of tough again for the Bucks. Thank you, Sparks. Appreciate it. Shamina, thank you. Good to see you. Scales of Justice, welcome, new member. Turtle Boy released a screenshot or something saying that he had 1,600 people in his members-only chat, members-only stream last Thursday. So he's charging $15 a person for that. That's $15 a month for his membership. So I'm going to need times so that's $24,000 right there. And those are just the people that were members who wanted to tune in that night, who were eligible. So maybe his actual total membership number is actually twice that. Oh, Jen is actually going to make it for a bit. Good morning, Jen. Jen, can you hear me? She may be just connecting to the stream, so I'm not sure if we're going to see Jen this morning because I know she was busy today, and I think she was just going to connect up her stream. But if she does come on, we're here, Jen. At the moment, her mic is not hooked up, so she may not be coming on because she had said to me she probably wasn't going to be able to come on today. But that's a lot of money that Turtle Boy is taking in. That's not even donations. That's just from the memberships. No, YouTube takes a big cut of it, but still. So you're talking about at least $25,000 a month coming in from memberships. So you can see the benefit of wanting to grift on this. Oh, I see we have Fan. Different angle on the fan. Trying to tease us. Let me see if Court TV has got anything going yet. All right, let's switch over the Court TV feed. Okay, good. So I have actually, this is nice. Wow, this is rare. Usually a lot of times it's like a couple minutes afterwards, still trying to figure out how to get a feed going, but they're opening up a little bit earlier now. So I am connected to the Court TV feed, which is probably going to be a few seconds behind the other one, but which the audio is very good. Cheryl, do you mean Fox 25 on YouTube or on their website? Because they have both. I've got to get my the Verizon password has been buggy here and haven't been able to set it in order to jump into my TV provider. So what I used during the trial was NECN, their actual website. I can't log into that at the moment because the login won't work. So I probably will go back to that. I'll get that set up before the trial. But this is working out all right too, though. So, and you guys can let me know what you guys think about. I get conflicting messages. Get rid of the caps. Add the caps. So, but I think Dawn is here, and I think she's the one that wanted the caps. So, hopefully, you guys can tolerate the caps. Good morning, Neela. Lisa, good morning to you too. Maureen wants the caps. Okay, I'm leaving the caps on. That's if Maureen wants it, I'm definitely doing it. So we got Maureen and Dawn. They both want it, and there's probably others. So caps will be on. And it does come in handy with this too, because if you don't have, so the audio can change on their end, and there's nothing I can do about it. And it's not too big a deal if you have on headphones, but if you don't have on headphones, you know, it'd be nice. I guess it'd probably be nice for even just people with regular good hearing to look at the TV and be able to see those caps in those moments. We have a turtle rider here, it would seem, named Gary Gluten, commenting about our collective IQ. Yeah, it was something after they, Valeska, after they came back from the lunch break, the audio changed. It was down, and it was I don't want to say echoey, but it sounded like it was in a hall or something like that. It was bad quality. Good morning, Jill. Yes. Okay, Karen. Thank you. Appreciate it. Yeah. So we've solidly decided from now on we will go with caps, and if the caps are on right now, and if for some reason in the future I forget, just always message. But they should probably stay on. Yeah. They should stay on unless I turn them off. So. Good morning, Karen. Do you have the day off? Karen from True Crime and Some Wine. I know Karen has a full-time professional day job now. So I just turned off the court volume for now, so we don't have to listen to the coughing and the sneezing. And but I'm right here, so as soon as that camera lowers down away from the ceiling fan, I will put up the volume. Oh, starting full-time next week. All right. I thought you already did. Yeah. You should have started after the trial. I know people who are listening right now. I don't want to give who are at work with an earbud underneath their hair, teaching a class. So if you're listening, not going to say a name, but giving you a silent shout out. Data girl, Liza took the day off for this. But if you take the day off and it ends up being Alyssa out there putting us all to sleep for 4 hours, you're like, oh man, I want to go to work. Georgia Mom or GA Mom, I think it's Georgia Mom, right? She's guilty too, she says, of the earbud trick. That trick wouldn't work with me if I was a teacher or had a job in the public because I don't have any hair to cover it. Caroline works from home up in Canada. Good morning, Caroline. Smitty Lee, bartends. After my own heart. I was a bartender many years, bar manager, then bar owner. So I'm always on the side of the bartenders. They should just let the bartenders make the decisions here. Because when you're a bartender, depending on what kind of place you work at, you do have to sometimes be judge and jury, and you have to be fair. You have to do your best to be fair about it. Jen, are you here?
Yes. Hi, how are you, Kevin?
I wasn't sure if you good. I put you on a little while earlier, and then I was like, I think maybe she just wants to watch and connect to it. But good to have you, though. Thank you.
Yeah, I was just going to come on for a quick second before I head out, but I just spent the morning kind of going through the breakdown of the ARCA payments. I had a lot of people asking me about that, and I finally had time to take a look at the total and I think come up with a very educated and likely a pretty close estimation on where those payments, how those were tallied.
Okay. And just so people, Jen has personal experience with this because she does work as an expert testifier too. So go ahead, Jen.
Yeah. So 23,000 paid, right? So I looked at the amount from Allenstown, Pennsylvania to flights to round trip to Boston, and it's 135 was the low, 250 was the high. So I'm averaging in about 200 for that per person, per expert. Okay, so that's 400. Then I'm giving them 125 a day per diem, and that's for meals and expenses. Now with this crew, they could have demanded more. I mean, obviously they eat at very expensive places that we've seen, but 125 is a very normal industry standard per day per expert to allot for breakfast, lunch, and dinner.
Yeah.
Okay. Then I figured in Uber transportation, right? They have to get to the airport, they have to get home, they have to get from Boston up to Denton and then back. And so I figured that at 100. And again, I went into Uber, I looked at the exact rates. It's $50 plus you're going to want to tip, and $30 from Allenstown approximately. So figured that, right? Then this is where the big money comes in. And that is $600 per hour per expert times 8 hours per day for travel, for testimony, prepping themselves, looking over their notes. I think 8 hours per day is probably spot on what they charged for 2 days, 16 hours times 2. I came up with $19,200 for their testimony, their related amount that they charged, just their hourly rate to travel. Okay.
Right.
And then
That's pretty close. That's pretty close to what they ultimately charged. So,
and then I figured 450 or 4.5 hours for prior prep with the attorneys, the list of Q&A that they were sent, going over that, preparing to come, telephone calls, all of that. And that was about 2,700, I think. And that came up to 23,000. So I think it's going to be pretty close to how those expenses were tallied.
So you're saying, like, for example, when it was listed on 1 day, 5 hours of, I don't remember what word they used. I don't know if they used the word prepping, but that prepping may not have involved them being on the phone with the defense team. It could have been just them going over their own notes and getting prepared in that way. Because there was things like that. Because there were things like that listed in there.
That's exactly right.
Okay.
So,
Good.
Yep. It doesn't necessarily mean, but again, I have to say, and I think many people feel this way, that I just can't trust anything I see now. I can't trust their documents. I can't trust what they say, because they've broken that trust whenever you're an officer of the court sworn to speak the truth, pending being sanctioned, and not only sanctioned, but your bar license being at jeopardy, and then also being found in contempt of court. When you're willing to risk all of that, how in the world can I think that anything you put out to the public or say publicly or anything else is valid? I just can't. But nevertheless, I think that is a very reasonable explanation regarding their charging.
Right. All right. So today, last Tuesday, it seemed like they finished up. So both sides got a couple of cracks at it. And even though they were pressed for time, but there's been no decision by the judge. So I don't know, is it going to be Tuesday Gazette mentioning that there might be questioning by the judge this morning? Is this going to, or are we just going to run right into the hearing on the dismissal?
I think we're going to get a decision today. I really do. I think that has to happen, because we need to know, she needs to know, everyone needs to know if Alan Jackson is going to continue representing Karen Reed.
Right.
And I think that's what the judge is leaning toward. And I say that I think there'll be harsh money sanctions of some nature, and a very strict verbal warning saying if this happens again, which I frankly don't think is enough, but I understand there's this Sixth Amendment balance, and that can be problematic. She wants to see everything move forward, but I think we're going to get a decision on that as well today.
Right. I don't know if you read the motion to dismiss at all. Do you think there's any chance that defense will get a dismissal of this case?
I did, and no, there's no chance that this case is going to be dismissed for a multitude of reasons. But let me just succinctly say it's not going to happen because the trial went forward before. And this is such a redo of everything. I know it's a new trial with new rulings. Everything is supposed to start fresh. But there's no way this is going to be dismissed because the probable cause that she committed this crime is strong. And even based on the allegations that were made in that, I don't think are valid. And I think that's what she's going to find.
Right, and the prosecution's rebuttal to that was very effective. That the main basis for wanting a dismissal would be the fact that this seems to be some unusual the way the Sally Port video was revealed piecemeal, last second to the defense, and then more coming after the trial, and more even coming just a few weeks ago. But as the prosecution points out, none of that video is actually exculpatory to the defendant. And it may even be inculpatory.
Yes, that. And the fact that just think of what little part that plays in this case. Really, yeah. When you think about it, what little part this motion, I always find it interesting that they're just, to me, this is just how I see it. And I'm not trying to be, one-sided. I'm just trying to say it's just grasping at straws when this is the biggest reason you can come up with. When the bottom line is the important part of that Sally Port video is it inverted, if that's the word we're using for it, it doesn't make what's there not there.
Right.
It just makes it there in a backwards fashion, but that doesn't make it not there. And secondarily, this is a rule, violation of Rule 14. Look at their violation when it comes to ARCA. I mean, laughable. And the fact, remember, they were able to come in town and look at whatever they wanted to. Remember, they wanted $20,000 back or something like that. For their expert that came all that way to review, but there was nothing there. They had all that time to review all of this. I'm just having trouble with really understanding the smoke and mirrors here and whether it's even real, if that makes sense to you.
Mm-hmm.
Their assertions, meaning their assertions.
Jenna, happy birthday. Jenna, it's her 40th birthday. What I wouldn't give to be 40 again, although if I was, I'd probably be hungover today. So, so the prosecution also pointed out, so they have now submitted into evidence video from the Sally Port from a month before, and that video was also inverted. And so they've submitted that to show that that's just the way that the system was recording. So it wasn't something particular to this trial. It was just not something that the prosecution or the witnesses, unfortunately, noticed. So they were all taken by surprise. Again, just I guess so much of maybe too much burden placed on a small prosecution team last year, just too much for them to do. Not enough time to properly prep with their own witnesses. Just so many problems like that. But so they didn't know that it was inverted. Somebody actually showed some clips from the trial on Karen's face. Now, I don't know if this was how accurate this was, but she seemed to pick up right away, sitting there watching it, that the video was inverted when she saw it in the trial.
Again, my position on that, and I think most people's position, is it doesn't change what was there. It just doesn't. And so for me, I just can't compute why this is a big deal, particularly since the video doesn't show anything exculpatory.
Right.
I just don't understand it. And again, what did we say from the beginning? That we guaranteed that was programmed that way. I've seen this so often. It's programmed that way. And that's what they're showing there. It's programmed that way. There's nothing nefarious. But this is what happens when you don't have real evidence to jump onto. You just lop onto anything that seems a little askew.
Hey, good morning, Matt. I hope you weren't sitting there long. That was the lower part of my screen, so I didn't see it, but good morning.
Hey, no problem. Good morning.
I'm headed out. Hi, Matt. You're
Hey.
going to take my place. See y'all.
Have a
Thank
good
you,
one.
Jen. We'll see you during the week. Matt, so I don't know if you've noticed this. There's apparently, if we're going to go by Turtle Boy as the person who is connected and throwing out the new theories, they're going with the idea. They finally accepted the fact, or at least Turtle Boy has, that it's insane that Michael Proctor or someone that the state police didn't know went to 34 Fairview from the Sallyport, from the Sallyport, and buried that taillight piece 3 feet down in the snow. So now they're going with the idea that it was actually a member of the CERT team. There was a seven-person special evidence recovery team in there. So they seem to be forced to changing their theory a little bit.
I mean, I don't know. I can't even imagine that that's actually coming from somewhere valid because it's just so outlandish and ridiculous. I saw another theory that Matt McCabe is the one that Googled how long to die in cold now. That's their new theory because he was downstairs. Like, it's just like these things are just so stupid and ridiculous. It's like, just look at the facts, look at the evidence. But they're searching for anything because even if, any of these other things did happen, it doesn't change the facts. Like what happened to our taillight? It's never been explained. There's no other explanation. I mean, we can see it at the 8 a.m. and I know that they paid money to clean up all those videos. And that was his response to this motion to dismiss, saying, we cleaned up all of those videos. We showed them the process. We provided the report. It's clear as day that her taillight is missing. So there's nothing to plant. These videos in the Sallyport are not going to be exculpatory because the red pieces were already gone. Yeah. And so you have to really think about that too, because if you were innocent, if you were Karen Reed and you were innocent, you would have been the one that cleaned up all those videos to prove that your taillight wasn't broken, right? But she doesn't want any clarity. Why would that be?
Well, see, and this also brings to the other theory that they're starting to float now. This was a theory that I first proposed during the trial, and people on this side got mad at me. They're like, "Oh, don't do that because you might give them ideas." I'm like, "They don't need ideas from me." But when you see that the video that shows that the taillight was clearly missing pieces at 5:08 a.m. and then it's clearly missing pieces at 8:22 with the dash cam. And Kerry Roberts is shown a picture taken from the Sallyport later on. And she goes, "Yes, that's what I saw at 5:30 a.m. that morning." It really does leave you no more room you're walking the plank and you've got just a sliver to stand on here. So what I suggested they might do was take advantage of the fact that the garage door wasn't opening or closing, and say that somebody broke into the garage before she left at 5:08. And I suggested that they might go with a theory that it was not only Brian Albert, but Kevin Albert. So the detective that works for the Canton Police Force. I thought they were going to do that in the first trial and they didn't, but now I'm hearing they might be doing something similar to that.
Oh my God. What is the deal with they spent a lot of time on the two different doors and which door she came out of, and his special car is parked in one Sallyport. I thought that she just came out of the far one on the left, but people were saying oh, she moved the cars around or something. I don't know if it's a real thing, but Lally did spend a lot of time on that and showing the other car, and I was like, is there something here? Why the door wouldn't shut? There's something there that he couldn't get out, I feel like. I don't know what it was, if it was something that's really important or not, but there was something.
Well, so my theory was, but I've never had any confirming evidence on this, so I don't even think Paul O'Keefe knows if this is the case. My theory is that because she normally doesn't park in there, it's a two-door garage. John parks there, and then he's got a hobby car in the next one. She doesn't, because remember, Karen is staying there a lot, but she doesn't actually live there. So she, but that because of the blizzard, being a gentleman, he backed out so she could pull into the garage. But because she didn't normally park there, I'm thinking maybe she didn't have a garage opener. It was just a theory, right? And that would, so when she leaves at 5:08 in the morning, if you were going to close the garage, let's backtrack even further. So when she gets home when she gets back to John's house and it connects to the Wi-Fi at 12:36, around 12:36, to quote Trooper Garino. But she doesn't actually pull into the garage until 12:41 because we hear that in a voicemail. So why did she wait? Well, it would make sense to me if you don't have a working garage door opener, so you have to pull up, you go inside, you use the bathroom. We're going to be going live in a moment. So I'm going to put the volume up. And then similarly at 5:08, when she left, she did kind of the same thing. So I'm on the feed I'm broadcasting with you guys is about a 20-second delay. So I can see on the other screen that it's come up. So it should come up any second now.
All right, please. Yay. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court before the County of Norfolk. Draw near, give your attendance, you shall be heard. Well, I say the Commonwealth of Massachusetts, this court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed. Can I just identify myself for the record?
Good morning, Your Honor. Ron Hoffman.
Good morning, Mr. Blackwood. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alex Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
And good morning, Ron. David Kennedy for Karen Reed.
Good morning, Mr. Nettie. Good morning, Mr. All right, so we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ARCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under dogger grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes of the Canton Police Station video. So that's the order that makes sense to me to finish up what we already had scheduled last week. If people would do anything else. So the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Alessi, that you said were welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you called it. Could you stand, please, because I can't hear you.
Yes, I was going to go to the podium.
Sure, go ahead.
Thank you. I didn't want to stand when you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between Arthur and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice.
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, in the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have to
I'm sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. I want to. So I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through. And when I got to the invoice, Before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ACA is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
All right. I'm not going to ask other counsel. All right. So let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I've marked them as exhibits. I didn't do that last time. The white book, and I had marked, Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1. So I picked off on 2 and worked it out to 4. What would you like me to do with each, Your Honor?
You can hand them to the court officer, who'll hand them to the...
Well, there you are. Thank you. Thank you, Your Honor. And have you concluded what you?
Yes, but let's
Okay.
Yes, 2.
All right. So let's go on to your, do the Commonwealth want to add anything?
No, thank you, Your Honor.
All right. So let's go on. I don't have to 499. So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I've read it. I read it 2 weeks ago when it came in, Mr. Leslie. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take
back
your
to
time.
it. Thank you. May it please the court. The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated with regard to Dr. Rentschler that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm. And yeah, you'd have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates a straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume hypothetically it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study. He doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support, but he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained. They have to give a fair and accurate depiction. And you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin. When there's any pressure, particularly with a bite, it moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read his. I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities in Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods in reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he didn't deal, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, et cetera, et cetera. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the deceased.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Are you planning on doing that in?
I wouldn't ask him to do that, no.
Okay. All right, so I'm here.
Yeah?
Yes.
Mr. Releasy tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case. And so in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Alisi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive. Variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Alisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he has, and I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's, the defendant's motion?
They
So
have.
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in this package.
I think that's attached here. I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it's not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was chief of animal care and protective services of the city of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project, 2023 to current. It's associated with Harvard University. Duties include the investigation and documentation of dog bite and related human fatalities. Also, division management consultant for animal care and protective services, city of Jacksonville, in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. And so when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured the distance of all of those teeth specifically. And then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Lisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources, and mindful, there was pig DNA found. So it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA. And so while there are different methods, and some of the things that Attorney Lisi spoke about, dentition, deal with human biting, not dog biting, his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him a new case in chief?
Absolutely not.
Okay. All right, Mr. Leslie, any follow-up?
I do, Your Honor. Thank you.
The Commonwealth did not address in its presentation, you heard, one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it, but the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number 2, Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now,
Hold on, so that's exhibit 1. and
yes,
down.
exactly.
Put it in there. Just put them back in. Alright, so what page?
Every page. The point is, there's now one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay.
So he's got it in alphabetical order. Importantly, the page before 1399 at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Dalbert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Dalbert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard, but what is it that he is participating in Harvard in? And this was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Anything else, Mr. Brennan?
Briefly. On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter of somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay, so before we move on to the next motion, the next motion was, it was filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, yeah, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your Honor.
Right, so I'll hear you. And this is paper 515.
May it please the court. Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes. So his certified weather statement is hard as a rock, I believe. I'm looking for it.
So I'm sorry, there are a couple of exhibits attached to your affidavit, Mr. Leslie?
Yes.
All right, so one's exhibit 1, I don't see any.
I'm sorry, Your Honor, it's exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement. It's an email, right?
no, his report is exhibit, well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that 1, he's qualified, and 2, that his methodology is reliable. but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Thank you. Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief. Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed. Talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock, and state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Okay, would you say that, Mr. Lessons?
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic, because just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze thaw effects on penetrometer resistance and shear strength.
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement. So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, or the cases and the qualifications of Dr. Crosby?
I can have that to you today.
Great, okay. And those articles, Mr. Leslie, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
You let me hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Leslie? Do co-counsel have copies?
Oh, no, the co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's.
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your
And
Honor.
that way there, we'll see to it, Jim, can you get a copy made for everybody? All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. And this involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Okay.
All right,
Can I just ask, is the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, we're going to see counsel.
Quiet, please, go the record.
I don't know if I'm muted. Wow. So that was a lot of Alessi. So basically, in the beginning, she says, one of you speaks for everyone. Like, I think that was like a big thing. Like, you can't just say, "Oh, I didn't know," and the other ones did. She asked him to clarify if he was inferring whether or not he knew that they didn't speak again to the ARCA experts. And he could not say he knew for certain. He had to say, "I infer," which is bizarre, which kind of tells me that they did talk to the ARCA experts in between that March and July or whatever it was. And then she confronted him about the invoice. Why wasn't the payment disclosed at the same time that the invoice was? Which, good question, right? I think, it seems like it leaked through, like it didn't mean to go out. They got it, and they were caught off guard on that first day. But he said, I did talk about how we paid it, blah, 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 whatever.
Good, thanks.
Hey.
Well, I don't know my mic keeps disconnecting for some reason, but hopefully it'll stay on. I don't know what's going on with that, but no, thank you. Appreciate that. So my quick observations, just the judge came out. Tell me if you agree or disagree with any of this. The judge seemed to come out and said, all right, the defense definitely misrepresented itself to us about the ARCA guys, certainly about the payments. There's no excuse that one lawyer can try to say, well, I didn't know what the other guys were doing. They were all in on it together. But that clearly she's going to move on from this without dismissing them. That's my interpretation. Do you agree with that?
It seems that way, because I feel like you wouldn't want to hear the other motions if you were going to remove them. But it's like, I feel like she should have said something, because that's why she postponed last week, right? She stopped the day because they were going to do this to determine what the actions were going to be. So it kind of seems like, I don't know.
Yeah.
It seems like it's going to be nothing. Like, what?
Right.
I don't know.
And then my other observation is, this goes back to thoughts that I've had with Dr. Russell, is there's a lot of talk about methodology, and that's all important. But the problem here is that there actually is no expert that is qualified in many ways to do this here, or not specifically qualified, because this is a very unique case where you're looking at very shallow, non-lethal wounds on a corpse, and you're only looking at photos that were taken during an autopsy. Mm-hmm. So whatever expert is looking, there is no expert that has probably ever testified to anything similar. Do you agree with that? Or
yeah, because I think most of the time, if it was a dog attack, it was a dog attack, and it's more about determining like how the person died or like what provoked it. But I feel like this Dr. Crosby guy, like when you Google dog bites, he's like the first one that comes up. He has all these things. So, I feel like he would be the expert that could testify to this. But like the methodology, Dr. Russell didn't have a methodology at all. She just looked at a picture, squinted her eyes, and said, "Those look like dog bites." Yeah. That was basically her testimony. She can't point out a single nail mark or a tooth mark, but when she looks at it from far away, squints her eyes, darkens it a little bit, looks like a dog attack. That's her whole testimony.
She's developed a methodology since that first trial, seemingly with the help of Alessi. She's talking about the fibers, but she didn't start out there. Right,
I thought it was funny.
Back in about 10 seconds, because my other feed's a little bit ahead.
Okay.
So go ahead. You can sum it up real quick, though.
I just thought it was funny how Brennan comes in and he's like, well, at least my expert wrote his own report. We can tell that this is Alessi's wording by how long, like, I don't know what he said, but I was thinking, you can probably tell by how long it is and how it doesn't get to the point that Alessi helped her write it, because she was just like, it looks like an animal and there's wounds in the shirt. Like, she obviously was coached. Like, my God.
So just looking at my other feed is about 20 seconds fast. So they re-entered the court, but then it went back to the sailing fan. So they're probably in a sidebar anyways, or on a break. I'm not sure. Actually, it says, I'm not sure. But anyways, we're not missing anything, even if you feel like you have to be up to the second.
What's the motion that they're doing now? Is this the sanctions motion?
Yes.
Oh God, this
Yes.
should be the good one.
And I know some part of this, the defense said they wanted to have this sealed and weren't sure if they should be able to argue this in an open hearing. So I don't know.
I thought it was Hank that asked for it to be impounded. And
Yeah,
but then he said, I want to be able to play certain pieces of the recording or something.
Right.
And she said fine.
I think a lot of us, understandably, even on both sides, get frustrated with Bob Alessi's long-winded ways. But I actually do think he's a very good attorney. You know, he's very thorough. He gets to the point of the case law and how to apply it and stuff like that. So I think it's a battle of very good attorneys here. Everybody involved is really excellent, even though they're not always entertaining to listen to. Do you agree with that, Matt? Or?
I mean, I don't think Alessi has a lot to work with in a lot of these circumstances, but he does make a good point about like going around the world and finding like certain case law that may support his point, like shakily. But I mean, I don't think there's certain things where, you know, you gotta work with what you have. Like you can't. Yeah. So, I mean, I don't think he's a great speaker. I don't think he is a good storyteller, but I think that he's thorough and he probably does a lot of good reports. I just don't think he's like I don't think he'll be good as like a direct examiner or cross examiner, but we'll see.
I think they'll use him just with the experts. But it was interesting that Judge Cannoni asked Hank Brennan if, as far as Crosby, if he intended to use Dr. Crosby on the case in prime or in the rebuttal, and I think he said in the rebuttal, right? So that's only if the defense brings their dog expert.
Oh, okay.
Did I miss that? I might have misheard that.
I didn't hear that, but I was wondering if rebuttal witnesses, like I've seen that in other cases, but we didn't have that here,
right,
in the first trial. So I didn't know if it was not a Massachusetts thing, but like I mean, I appreciate the rebuttal witnesses better because you don't put in all your nonsense, you know what I mean, right up front. You only bring them if they're going to go this crazy route of dog bites and you know, all this other stuff.
Yeah, so I wonder if there's a legal distinction there. Oh, NF Cat said correct. So I wonder if there's the standard for allowing this expert is somehow different if it's a rebuttal expert versus a case in prime expert. I don't know. It's just interesting how the judge asked that. Or maybe he's asked that before and I just never noticed. I don't know.
Yeah, I'm not sure if that would be different.
So we'll see. I don't know if this. So everybody is certainly on one side is really hoping that Alan Jack, Hank Brennan will reveal today that the federal investigation is over. It was kind of shocking to people, me included, that he didn't get the chance to do that last Tuesday. Is there going to be an opportunity for him to say that here? What coming up in the discussions, these motions, the motion to dismiss, is going to allow him to bring that up? It seems like it would have been case in chiefs. Yes, thank you, Rainey. I don't know. Is there going to be a way for him to get that in here?
I feel like it could be. I mean, he might be waiting for the perfect time, but like it could just be his first sentence. Because remember that hearing when Hagen's lawyer came in and Albert's lawyer came in, and that was like I think it was the first thing they said. They said, we got clearance that the federal authorities told us that we're not the target. None of these people in this house are a target in the investigation. So I feel like he could start with that. I mean, he probably strategically wants to do something with it, I'm sure. He probably wants to let Alessi talk himself into a hole and then reveal it. I don't know. I mean, he's probably saving it for something good, like, you know, a bomb.
Yeah.
But who knows?
It would have to be some issue related to the feds or to ARCA or something like that. And I'm not sure where that's going to come in today. Because I don't even think is there going to be any continued discussion of ARCA today? I don't even think there is. I think that issue's done.
Yeah, I think so.
So
I think it's all about what her determination is going to be. I mean, she never makes determinations on the same day, usually. Right. But Jennifer was thinking that she was going to make that decision today, so you never know.
Right.
It sounded like she already had studied up on it and already kind of knew that, they lied and lied and lied, but it still doesn't negate what happened. Right. So she kind of pointed that out right at the beginning. But then she's letting them do the other motion, so it's kind of confusing.
What do you personally think about the judge's instructions in the first trial that nobody could mention the existence of the federal investigation?
I mean, I think that makes sense. It's just going to cause confusion because it's like I don't know which way it would prejudice people. It could be either way. So like no mention could, or if they mentioned it, they could make people think, oh, there's really something going on. There's something to this cover up conspiracy, right? Because the feds are involved. Right. But then if they find out that the federal investigation completed with no results, that would be like prejudice the other way.
I'm not sure how they'll find that out though. How could that be introduced in trial? I don't think there's a way to do it. Right. Because you're not going to have someone from the U.S. Attorney Office go up on the stand. So I don't know. There might be a way. So the witness, they've avoided the court, right? But the witnesses were informed by the Norfolk County DA's office that the investigation is over, that the U.S. Attorney's Office reached out to them. So maybe they'd be allowed to say that. I don't know. Or is that just hearsay? I don't know, man. We'll have to send you to law school, Matt.
I know. I mean, I feel like the usual ground where Fed and state are mixed together like this, and I think that's why. And so that's why, like, some of their argument where, like, we're confused about, like, what's going on. I feel like that partially is true, even though they're the ones that started the investigation. Right. They probably were, like, it doesn't make sense, though, that they're going to pay a bill for people they didn't hire. Like, it just does not make sense.
Right.
That story is just like bogus. Right. So like, we want to know what really happened, but that's the story they're going with.
So do we want to see the prosecution being able to explore that in front of a jury? I think that the easiest solution here, especially if the U.S. Attorney's Office does not allow the Rule 14 discovery where they provide their messages between them and ARCA, and unless something has changed, they're not going to allow it. So I think the easy solution is just to treat ARCA like regular defense experts. Don't mention the federal investigation. Don't mention the federal investigation is over, but don't treat them as they shouldn't be allowed to present them as independent. They should just be experts that go up there and present their opinions based on the evidence that they looked at. And that seems like the simplest way to do it.
I feel like they're going to get destroyed, though, because it's going to be like, well, why didn't you have the tech stream? And why didn't you have this? So your opinion is based on, like, nothing? Like, you didn't even have the measurements of where the debris field was and where the body was. Right. And, like, you didn't even use that to come to your conclusions. Like, you tested the head hitting the taillight and you tested shooting the taillight with the glass. Like, how does that equate to you coming to your conclusion when you didn't even test the obvious scenario of his arm hitting the taillight? I don't know. It's bizarre. I think the jury's going to be like, what the fuck?
Well, but what if they have that evidence now and they make that part of their study and they still come up with the same conclusions? In a practical way, we in the public would say, all right, that's confirmation bias. They already, like Dr. Russell, she looked at the photo, and over the subsequent years, she's developed a methodology, but it's just to reinforce a conclusion that she already made just by looking at the Boston Globe article. So, yeah, I don't know. I'm not a lawyer, but this is obviously just a fascinating, how do you split this here, even just to try to be fair to everybody involved. So,
yeah, this case is spilling over everywhere because it's like all of the intimidation of the witnesses too. Like, that's not a part of the case, but I feel like that is an extreme, like, tell of herself. Like, all of her interviews, like what she did to the witnesses. Like, this was so orchestrated and it's all part of the same crime. So, and they want to keep it separate, right? I mean, I don't know what's going on with Turtle Boy this week, if things are going to come out, like communications between him and Karen. I think that stuff is just an important part of this case, because that's why she's sitting there and smirking the whole time. It's not because it's because she knows that she turned most of the public against all these witnesses, and that's why she's smirking. Not just that she killed the guy, but that she turned everyone against the people who are telling the truth. And everyone's like, most people are believing her. That's why she smirks. That's why she sits there and smirks. And like, I think the jury needs to know that she's smirking because she duped everyone. Duper's delight.
I feel like whatever comes out of the Turtle trial, it'll be like 50 years from now. That is the slowest moving glacier of a case ever. It's just nothing ever seems to happen. You know, it's unbelievable. I know there's obviously some difficulty with the special prosecutor being very ill, and I don't know. I'm not sure what all the issues are, and obviously the need to get a taint team to go through the messaging that really slowed things down. So there's a lot involved, but it's just maddening how slow that case moves.
Yeah, and I feel like I don't know. It's kind of by design. I don't think they want it to go forward before Karen's.
Right. The state. So you mean the state doesn't want it to?
I think who knows what they want to keep separate, but like for me, like I would want Turtle Boys to go forward so we can get the information and potentially use it in discovery in this case. Right. That's linking her to harassing all the witnesses, because everything is about harassing the witnesses. The Fed investigation is about harassing the investigators. It's like, that's what she's done with her time. She like got on a platform. She like had people spread information across the internet. She went to the feds, said there's like this conspiracy and they're framing me, and oh, poor me. Damn.
This is actually, let me just turn the volume down. This is all right, so that is from the court feed. So that's because I have it on two different channels and they're both showing that same thing. So that's just on the court feed.
Maybe Karen's going crazy in the courtroom trying to eat people's faces and stuff.
Yeah, she's pretty aggressive. We all know that. That was famously John's friend Carl Dougal was going to he got banned from the hearings because of this, but she kind of charged in his direction and he didn't get out of the way fast enough. So she accused him of giving her a hip check or something like that. I don't know. They reviewed the audio and my sources say he didn't do anything wrong. Didn't do anything like that, but they just threw him out on to err on the side of caution thing, you know?
Her
one
show's
of the things,
coming
Matt,
out soon too. Oh, sorry.
What show?
I'm just thinking about her show that's coming out March 17th, because in that she's saying a lot of contradictory things, and like you hear Proctor saying, "See how crazy she is." Did you see that part? He's like talking to when they're arresting her in the spring. He's like, "See how crazy she is," and that's when she was making those statements like Brian Albert and Colin Albert beat him with my taillight or whatever. I don't remember exactly what her words were, but that's when she was indignant about. Like, she was very humble when she was first arrested, but then by that point in time when she was arrested the second time, she was very indignant and aggressive. So
right.
I don't know.
Yeah, I'm curious to see how they do that documentary. So I was in it in a small role. I do talk to them a lot, the production person for it. She's become a friend. But there's no narrator, no narration. So it's all done just through Karen and the other people that they spoke to. They spoke a lot to John's friends, Brendan Kane and John Jackson, and those guys really are outstanding spokespeople that emerged after the trial. Before the trial, they were obviously very closely involved, but just wanted to trust the process and stay out of the media. But after seeing the way things went, they made the decision immediately after the trial to take a more active role and trying to get some balance out to the other side of Karen's message that she puts out, that she floods the airwaves with. We'll see how it goes. Oh, so I wanted to ask you this. So one of the things that a lot of the defense lawyers seem to say that I think they get slightly wrong, but they say a tie goes to the defense. So if you have two different experts come out and one says it's dog bites and one says it isn't, a tie goes to the defense, right? Or same thing with the Rich Green data, the searches and the stair climbing and stuff like that. The reason I say that doesn't apply in the way they think it does is if that piece of evidence is somehow part of the cases of the case presented by the state, and it's a fundamental reason for their argument, then yes, if there's a tie in evidence like that, that goes to the defense. But these are arguments that are raised by the defense. So the state's case doesn't in any way depend on showing how the wounds occurred on John's right arm.
Right.
The only reason they even have to show that is because the defense is saying that it's dog bites. So I don't know. What do you think about that? Are you seeing lawyers say that a lot too, or?
Yeah, and I think it's out of context because they're talking about when you have experts that are arguing about like how, you know, a person died basically, and like you have two different experts, they cancel each other out, and it goes to the defense because of reasonable doubt. But in this case, it's not the same because I don't think it's a tie either. I'm just trying to think. I just think that most people logically are going to be like, yeah, those aren't dog bites. Like, if dog bites didn't kill him anyway. So it's like, why are we even doing all this effort to like prove that this dog had no DNA, but somehow it grazed its teeth on one side of the arm, but didn't puncture the skin, but punctured the clothes? Like, it doesn't make any sense. I just think that the jury's like...
And very similar along that line, Brother Counsel, and also... to some degree, Vinnie Politan, they will look at an isolated piece of the defense argument and say, this creates reasonable doubt. Again, kind of similar along the points of a tie. But what bothers me about that approach is that they're not looking at the totality of the evidence. So even if we can't determine beyond a reasonable doubt what the cause of John's wounds on his right arm are, there's a whole lot of really important evidence that we have to look at. And so it's I think it's a mistake to just take something like that is not essential to the state's case and put it in isolation and say, well, because you can't prove it exactly, now it's reasonable doubt. I don't know. Does that make sense? I probably didn't say it that very well, but
yeah, I mean, I think that defense attorneys in general try to misstate what reasonable doubt really is. Yeah. Like if you think about like Scott Peterson, Lacey Peterson disappeared. They don't know how she was killed, when she was killed, or where she was killed. They just know that she disappeared one day and she was found where he went fishing the next day. And he was convicted. So like there's reasonable doubt because you don't know how it happened, when it happened, anything. But you know that he was there, like there's evidence of her in his like boat or whatever. So I mean that's all that took.
Right.
And like to convince people that it was beyond a reasonable doubt. So in Karen's case, like they have down to the second of when he stopped moving and when her car went in reverse and like this and that. Like there's so much evidence here compared to a normal murder case.
Yeah.
It's like unbelievable. Like down to the second we know her movements. So it's like, okay, that's not reasonable doubt.
Right. Are you covering any other cases now on your channel?
I'm not really. Like, I mean, I guess I'm covering the Idaho 4 like lightly. I feel like this case is just like, I don't even think I ever want to get into the details of a case like this again. This is just too much for me. I feel like I know too much to get out now, but like, I'm like, just please let this be over because it's torture. Just all of the misinformation and like how aggressive people are. And it's just so negative that I don't love it, but I feel like the right side didn't have a voice for so long, and that's why I started talking about it. But now I'm here, and I know all the little details, so I feel like until this is over, I can't be done with it. But
I know that's how I feel. It's like we got to see it through to the end. But I hope I'm just praying there's no postponement. You know, just get to the end. And what happens if you get another hung jury? Oh my God, it's just it's hard to even weigh it. You know. And there's a pretty good chance of it because you only need one juror, you only need one turtle rider to get on that jury. And there's a very good chance of that, sadly. There was one that got on the last one. So people are willing to lie under oath to prove themselves to this cause or to Turtle Boy. That's the cultish aspect of it, you know. I would not, if I got summoned to jury duty for Karen Reed case, I would be upfront and say, you know, I followed this case extensively, so yeah, I'm not qualified. And but there's people that won't do that, you know.
It's so weird though. Like, why would you risk getting in trouble for that? Just like, they expect that all these people risk their freedom and their livelihood to cover up for Karen Reed. Like, I don't believe that they actually believe this. I don't know what they're thinking. It's just like, this is their cause. They're a part of something for once in their miserable lives. And so they're going to free a killer. And like, that's it. They're going to put it on their tombstone. Free Karen Reed. Congratulations. Your life was a complete waste. Like, my God.
Andy wants to know if the woman who interviewed me was short, brown, curly hair. So the woman who interviewed me, her name is Terry Dunn Muir. I'm not sure if I said her last name, but she founded Unsolved Mysteries. She still owns it. And this was her first kind of independent project of that. And very, very nice, very experienced lady. She was with Karen for something like, they filmed like 500 hours, some crazy amount, but they were with her, I believe, during jury deliberations. And so they got hours and hours of footage. Also, she asked what she was there. So when I went to the Dedham hearing, I think maybe your parents were there for this one too, Matt. This was one of the ones in August. She didn't arrange to meet me there, but when she walked into the blue crowd before I got there with her camera crew, people were suspicious of her. Who are you? They didn't want to talk to her. So she said, "Oh, I'm with Kevin," which she's not technically with me, but I didn't really mind because, like I said, she's a really nice person. So then when she said that, they started talking to her. And so I think some people actually might end up being in that documentary from that day too. So it ended up being interesting. You're lucky you don't have to. You're not in Massachusetts anymore, so you don't have to even feel tempted to go into Dedham for any of that madness.
Oh my God. Yeah. I mean, if I was there, maybe. Who knows? You never know.
Yeah.
It just seems like so much negativity though. Like this has turned into such a circus.
Yeah.
By design, and I think it's like, I don't know. I think it's partially the judge's fault for letting too much go on. Without nipping in the bud, because people do have the right to a fair trial, but like the stuff that her attorneys have been doing all along is just so beyond unethical that, they should have been, I mean, whether it was a gag order or something, there's other remedies that should have been put in place by the judge.
So we'll be starting any second now, because I see in the other feed, they've already started. So we'll be back in a moment. And maybe if you're still with us after, you can tell us about your opinions on the Idaho 4. I'd like to hear that too. Daniel covers that for Drunken Turkeys, covers that case extensively.
Oh yeah.
So I followed it a lot until they arrested Koberger.
Yeah.
And then I kind of lost a little bit of interest with it. So actually, I don't know what's going on. We're going to see in a second. They came back only for a few seconds to go back on break. So
they're fighting about it.
And it looks like the Court TV feed must be like a full minute behind. So sorry about that. Maybe even more.
I think it's about the audio. Like I bet the defense doesn't want them to play the audio. And Brennan's like, I'm going to play the audio. Right? Because this is that about the Gretchen Boss interview.
Yeah. Oh, that's okay. All right.
I think.
We'll see what they say. It's going to be very quick. Then they go out right back on break.
All right. So the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48. Mr. Leslie, do you need a minute? Did you need a minute? I saw you just.
Could I please just? Sure. Thank you.
Jimmy?
Yes, I'm working on something.
Why don't I take a 5 minutes?
All right, please.
Oh boy.
Why does Alessi need a minute? Like if it's the Commonwealth's motion, wouldn't they speak first?
Yeah, that's a good point. I don't know. Maybe he was having some kind of a physical episode there. I don't know.
Yeah,
she looked a little
weird.
concerned for him, so I don't know. We'll see. Or probably just didn't have the right giant book of notes that he's going to go in for this one. You know? So what do you think about the Idaho 4? Any thoughts on that?
I mean, I think the big thing is like they had a gag order. So anything that's come out pretty much since he's been arrested is, maybe sources, but we don't really know. There's some stuff that came out during some of the hearings that we know. But it doesn't seem like the defense really has anything. Like they took 1.5 years to come up with an alibi.
Right.
Which tells me that they were waiting to see where all the tower data put them, all of the cell phone movement. And they waited to get all that before they came up with an alibi, which is not what an innocent person does.
Right.
And then they're attacking the DNA that was found in a knife sheath beneath one of the victims. They're trying to get that excluded. So and then they're talking about the one roommate that saw him. She was drunk. I think we all kind of assumed that. She was drunk. So like she had a bunch of interviews that she was like, I don't know. Like she was just confused. But it doesn't negate the fact of the rest of the evidence. But they're trying to say like, oh, she's not. They relied on her to make the arrest, so the arrest is like invalid. I mean, I just think they're grasping at straws, kind of like Karen Reed's defense.
And I think I'm curious to hear what you say, but I'm sure you agree on this. It's not that we assume that there isn't corruption. There are corrupt cases. There are false prosecutions. There even are. It's rare, but planting of evidence, right? It's just. So here, we're just trying to follow the actual evidence here. So it's not like we start out like saying, there's never a corruption. The police, we're not on the side of the police. We're just on the side of the evidence and the logic.
Right. Yeah, and I think people got into this case because of the corruption is like what sells. Conspiracy, corruption, people being framed, people being locked up, and, someone else did it. I think that was like the first true crime podcast that ever was the guy got out of prison because of it. And I started listening to that one, but I haven't finished it. But I think she did a good job, and that's what kind of kicked off the true crime podcast in general.
All right, I'll put this.
Brennan, I will hear you on this motion.
Back in action.
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watch other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of a jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on court TV with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is...
When was that court TV appearance?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them. And the Commonwealth will not speak either. Ms. Reed, I'm not asking for a gag order for it. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions. And that's what I'm asking for. Thank you.
Mr. Nitty, you're arguing this, you said?
Yes, Your Honor. May we approach, please?
Okay.
Oh, boom, there it is.
Yeah, finally.
Yeah, that's a lot of relief for the witnesses now to be able to, that has been said publicly, just to think about what they've gone through in this last year and a half, and a lot of relief for them. So my heart, and to the end, not just to the witnesses, but to the investigators who've been accused, and even the attorneys have been really smeared, besmirched, as Hank said. A lot of relief on that, so that's good.
Yeah, these sanctions, though, I feel like it's not, I mean, it's a month away. I feel like the damage has been done. So it's like, even if she grants it, it's like, what is the big argument here? Like, the defense should just be like, okay, we're not going to do anything. I mean, are they really even going to have time to do anything else? There's a month until the trial starts. So, I mean, Karen Reed can keep making statements all she wants, but I don't know.
That's right. At least they got to say it, gave them the excuse to kind of slap them in court, you know, in a public hearing. So, and it's fully justified. This has been an unusual, not unique, but an unusual trial to the extent to which the defendant and her attorneys have run this as a PR campaign with the goal of contaminating the jury pool. Not the first time it's happened, but one of the most notorious times at this point, I'd say.
Yeah, I mean, I feel like this case is, people are going to look at it and be like, all right, we need some changes. There needs to be, I mean, I don't know what it is, what the changes need to be, but obviously you can't just let people run propaganda campaigns against all the witnesses in their trials. Like, this is not how justice works. You can't just harass all the witnesses so that they're scared. And it didn't even work. I mean, they all, you know, nobody's story changed. If they were lying, they probably would have changed the story, just to get away from the heat that was coming to them. Yeah. But I don't know.
Be back in a second. So Turtle Boy, after I first reported that the Fed investigation was over, said, Plevin lies. I have my own information that says that's very much ongoing. Then Ted Daniel from Fox 25 reported a couple days later the same thing. And he changed his story to, well, I always knew the Fed investigation didn't matter anyways. That was more Sean's thing. And then when Hank didn't say it Tuesday, he went back to, I have my own information that says this investigation is ongoing. Well, why do people in his crowd take him seriously? How many times does he get to lie to them before they say, hey, this guy's lying to me? I mean, so I don't.
Yeah, they're not seeking the truth. They're seeking a leader. And I think that's like kind of what we see it like on a lot of these things, like politicians and, it used to be the churches used to, get people in this way. And people are still searching for that belonging. And I think that's what it is. It's not about facts.
Yeah. Yeah. It's like a new religion. All right. Thanks, Matt. Let's go.
And thank you for the support. Your Honor, as I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate. And I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication brought by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I didn't. I do have concerns about my ongoing obligations, so perhaps I could have a moment, Sandra.
Sure.
So something like grand jury minutes are really kind of sacred, and they're protected. And in this case, this is the federal grand jury. So this is something we don't have access to, but both the defense and the prosecution do. So I think that they're in sidebar now because they're going to discuss a little bit of that. Did I get that right?
I think so. I wasn't sure what she's moving on to next. I missed that, but I guess I'm just like looking at Yanetti's demeanor, and he is so humble right now compared to his usual indignation of, I've been accused of lying. Like, now we know you're lying. And now he's like, oh, my mistake.
Yeah.
Give me a
Oops, I didn't mean it.
break.
It was an accident. And I can prove it was an accident because I didn't release that information that was impounded because it didn't help me to release that information. I mean, that was the real thing. Like, he didn't leak out the name of John's niece because how was that going to help the message that they were trying to distribute to the public? So to me, that example he gave there just kind of showed that he knew they weren't supposed to, and they did it anyways. So that was really a bad defense. He should have had a Leslie defend him on that one, but thank God he didn't.
I mean, I just feel like that motion was, I'm trying to remember, that was the one where they're arguing about, they brought up the steak tips, they brought up Proctor, and then they brought up the, they wanted to test in the driveway of the O'Keefe's property. Right. I felt like that whole motion was like, damn, it's like a month before trial and this is all you got? You're going to argue about goddamn steak tips that the kid didn't remember 2 years later what he was eating that night. He just remembered she got mad, called it takeout. So that means he was lying. Oh, and then Jennifer McCabe's like thing that they kind of already addressed in the last trial, and Jackson declined to do anything about it. But like, the whole thing about Proctor texting Lally, like, they definitely just put that in there so that people were like, oh, the investigation's still ongoing. I mean, that's what I took from it. And that's what I was surprised about. I was like, wait, so there was more disclosure because they got those pages before the trial, the 3,000 pages. So for them to know that he texted Lally, that means that they were still looking at him all throughout the trial, or looking at everybody maybe to see if there was collusion, and there was none. I mean, that's the real kicker. But so I guess they got another disclosure from the feds at some point, because how else would they know this?
So, man, if you're a Karen Reed person, how do you process the fact that the feds dug really hard into this case and found nothing? How do you still believe in a conspiracy? You know, I don't really understand that, you know?
I know that there's one that's always on Twitter that's always like, well, what do you expect them to find? That's the real question. Like, that's how they're pivoting now. I'm like, well, personal text messages, you would find some kind of pattern of, you know, code or something that they were talking about, but there's no activity around when any of these things would have happened, which is early in the morning, right? Like early that morning, like they're saying, oh, they were all conspiring in Brian Albert's kitchen after after John was taken to the hospital. That's not when they would have been conspiring. They would have been conspiring in the middle of the night. Nobody would have slept that night. They would have been cleaning all night. There would have been blood trails out to that spot, footprints to the house. Like, there's no way. And like, so it's like all the things that they like are like, this is suspicious. These are normal things. If a dead guy's found on your lawn, you're going to be sitting in the kitchen thinking and talking and shocked and trying to figure out what the hell's going on. You know, those are normal things that people do, and they take all those things that normal people do and try to turn it into something else. And they go for it every time.
Brian Higgins submitted just before trial his medical device, which showed he was asleep by 2:37. He has sleep apnea. So if he's just committed murder and he's trying to cover it up, and actually John is still alive, but he's going to sleep, and they can prove that. You know, they, like you said, they have, not only did they get the message, they actually got the content of the messages of everybody in the house. They get all the phone data of everybody else. Even loosely, anybody that Karen pointed to, they got their phone data. You know, so we don't know, but I'm assuming they got geofence data that would show specifically who was in the house and what time and stuff like that. And did they get geofence data of Chris Albert's house, of Brian Higgins' house, things like that? So we don't know. We don't know. But Vinny said Vinny Politano was on Melanie Little's channel the other day. And he said the federal investigation, I can't remember the exact word he used, but basically weak. Like it was not deep. It was not a deep investigation. And I'm not sure what he based that on, because it seems to me it was pretty deep. First of all, you had a federal grand jury. You had subpoenas that went out for the content of all the messages. Then you had warrants that went out for the content. You had subpoena went out for the records of the phone, and then you had the warrants that went out later for the content of those messages. That seems like about as thorough. That's more thorough than what they did with Birchmore. And Birchmore, they've now got an indictment.
Yeah.
So I don't know why people would say that the federal investigation was not thorough.
And was Dr. Crosby part of the federal investigation or no? I thought at one point Hank Brennan mentioned him as to the dog bite lady, saying like, oh, well, I remember him bringing up Dr. Crosby, but it might have been another person that also was in the, I think part of the Fed investigation, someone did look and say those aren't dog bites. I don't know.
Yeah,
if
they
Dr.
reached
Crosby,
out to, I think there was two people they reached out to, and Hank, definitely at least one, but I think maybe two, and Hank quoted them. So they reached out to experts. They reached out to, I wonder if they got a medical examiner. That might have been the person. That might have, I don't know.
That might have been one of them. Yeah.
Yeah.
I would think that they would. I mean, I think that's like one of the main things. And then ARCA, it's just, I mean, I don't know. They wanted to get Proctor. It seems like I mean, that seems like that's who they were after, and they really didn't get anything. Like they didn't get anything. Like they were even monitoring during the whole trial. So like if there were things he was like slipping to Lally, they would have had all that, and there was. I mean, obviously there was nothing. They didn't bring anything up.
That's why I say this guy's one of the most vetted cops there is now, because they went back 5 years to get into the content of his messages. It almost seems like unbelievable that the guy didn't fix a speeding ticket or something in 5 years. But this guy seems to be kind of like Sergeant Joe Friday by the book. I mean, they didn't find, because they not only did they go into it, but the state once those insensitive messages came out, we have a very liberal governor here, and she wanted to find an excuse to get rid of him. And they left no stone unturned. But they didn't find anything. All they have is the same stuff that we heard in the trial. And I'm not diminishing that. Those messages were extremely insensitive. I'm just saying, doesn't seem to be any corruption despite being a detective for 5 years.
Right. And I mean, I just think, I don't know. It's just unbelievable because those are like private messages. I'm sure that if we looked at like the arresting officers for Chris Watts or like any of these other like killers, they're going to have some choice words about these people. I mean, being a police officer, a detective, a homicide detective is a stressful job. You meet very shitty people. It hardens you to a degree. And to say that his like messages are insensitive, Karen was using that same language when she talked about Kerry Roberts. We've seen it in messages. So, I mean, it's like, all right, let's treat them the same. Okay, they both use bad language. All right, it's not a crime. Like, I mean, in their own free time. So, I don't know.
Hey, looks like we're coming back in a second. Another thing that we can talk about later, Matt, is it seems to be a common thing said by many people, even some people that are on the fence like Vinnie Politown, that this investigation was really bad, really sloppy. And I think that's something to talk about. I've talked about, it's hard for us because we're not cops. But, I mean, no investigation is going to be perfect. But was this investigation sloppy? I'm not saying it was or wasn't. I don't know. I'm not exactly sure, though,
Yeah, I mean, I personally don't think it was, considering it was a blizzard. I think that every case they bring up things that the investigating officers did wrong, whether it's chain of custody, whether it's, you knew this person's cousin back in high school. Like, that's all the kind of stuff that the defense teams always kind of go after. So I just don't feel like there was anything so egregious here. Like, yeah, the solo cups, but I mean, I feel like they just were trying to get it off the ground because the blizzard was going to swallow it up. So they scooped up the blood into the solo cups. Like, I think that's not, I mean, that's a little bit sloppy, I guess. But at the end of the day, the evidence, the crucial evidence is, I mean, you can't deny it. That blood evidence really wasn't used for anything. What it could have been used for, if it was a cover-up, was to throw it on the back of Karen Reed's car. But we know that they didn't do that. So it's not a cover-up, people. Like, they had it in the Sally Port with the car. That's what would have happened if it was a cover-up.
Right. It's important to look at the things that there's signs that would be there. If there, like I've always said, so the Proctor and Buchanan, when they leave the Canton police station, where they've talked to the first responders, they go to the McCabe's, where they talk to Jen and Matt and Brian Albert. But then they don't go to the Lexus. They go to the hospital. The Lexus is only a mile away. If there was ever a moment when the conspiracy was going to be plotted out, it would be in the McCabe kitchen, where the troopers would get their marching orders. And job one, I believe, in evidence planting 101 is getting access to the vehicle and prying off some pieces. But they didn't show any urgency to get to that vehicle that's sitting alone in a driveway a mile away. So they could have towed it then to the Sally Port, and then they could have had their ghosts do their work. So, I mean, I don't know. So I'm not sure. There's no investigation is perfect, but just a lot of the things here. We were told at one point there was a picture of the clothing in the emergency room near Trooper Proctor's feet. Look at how sloppy he was with the evidence. But we now know that the clothing was taken off on the ambulance, and as it's always done, and that's the first responders and then the doctors. They're trying to save John's life. They're the ones that pile the clothes up on the floor. They don't have evidence bags, and they don't have any training. So Trooper Proctor didn't do anything sloppy with that clothing. It was already on the floor when he goes over and bags it. So just on and on and on and go. Most of the stuff that we're told is sloppy really is just not. It has a normal explanation.
Right. I mean, I'm wondering really what they went in and told the feds to get the feds to be like, oh, they must be telling the truth. I mean, I guess like not interviewing all the witnesses. Some of the witnesses that were in the house for a long time, I guess maybe that's one thing, but there was no conflicting information. So it's like, I mean, I guess you should interview everybody. I don't know.
Yeah. Yeah.
That's the thing that I'm like on the fence for, because I can see like, okay, but they thought it was a hit and run, and Karen's pretty much admitting to it. Like Yannetti was saying it was an accident. So like there was no question about what happened until a year later, basically, or 8 months later. So I can see like, yeah, you've talked to a bunch of people. They didn't come in the house. Like Karen's didn't say he went in the house either. She did a 3-point turn and left. That's our story. So like, why would you be searching the house? She never said he went in the house. Like it's I don't know. Like that's where they get it. So like they kept this a secret or didn't come up with the conspiracy until like way later after they sold the house. They could be like, they sold the house, they got rid of the dog and did this and that. Like they took a year to cover up the murder. They got rid of their phones 8 months later. It's like all this like circumstantial crap that normal people do that they're trying to like tie into it, and it's ridiculous.
I think I think the one area where I thought was sloppy was not talking to the plow driver, and apparently it sounds like they were given some false information on that, or there was some confusion where they thought the road was not plowed, so they didn't think. I mean, if you know the road, you don't have to talk to the plow driver because of the conspiracy. You have to talk to the plow driver because even for the state's case, you want to know what he saw, if he saw John lying there, So,
well, I would hope he didn't. If he's just plowing along, sees a guy in the road.
Well, yeah, that's true. But even just to say that I didn't see anything or whatever. I mean, I just think if you're doing an investigation and a plow driver went by where the body was, you want to at least talk to him, right? But I guess they were told that it wasn't plowed. Now, had they gone to the crime scene, they would have seen that it was plowed. There was one lane plowed up the middle of the street, but they didn't go to the crime scene that day. So it's, a little bit of that's it. That's the only thing I can really think of here that was kind of a shortcoming in this investigation.
I mean, I think a big part of it too is like that it was a state of emergency. It was the weekend. And like, I don't think there's a ton of murders in that area. So even Proctor is probably not the person that takes pictures. It's like that forensic team that comes in, and they didn't get there till the next day. So it's like, that's not part of their duty. So like, even like Canton PD is not normally securing a crime scene, right? So like that they had to do what they had to do that day because it was a state of emergency in a blizzard. And so I just think that those are things that they're trying to make into something that they're not. I just find the defense like so, I don't know. I just feel like this defense is just so unethical. It would have been so easy for her to just say, I didn't know that I hit him, which is what she originally said.
Right.
But I guess maybe, I don't know. She doesn't want to take any accountability for it, I guess.
She said in an interview that came with Fox 25 that came out, the most recent version of it, she said that the next day, so her lawyer told her to get a private investigator and retrace her steps. So she did this, according to her, the very next day with blood still in her hair, with John's blood still in her hair. Then she went out with a private investigator. Now, I know that she was arrested on Tuesday, a few days later, and then she spent the night in jail, and Wednesday in court. If she had said in any way, shape, or form, I don't think I did this, then David Yannetti would have stood on the stand and said, Your Honor, my client is innocent. We look forward to our day in court. That's like a standard response, right? Didn't say that. So she could not have had any notion at that time that she didn't do this. So what would be, do you think she's lying about going out with the private investigator? Is that standard, do you think, maybe in a hit and run for the attorney to get her, her to do that with the private investigator? I don't know. I'm just kind of curious about that.
I don't know. I mean, I just think that she knew that she hit him, I think, from within 15 minutes. I mean, I think she knew she hit him immediately, but realizing what happened was like a slow roll because she was drunk. But I don't know. I just don't think that I just don't believe anything that she says. like some of her actions. So like, Carl Dougal is John's best friend, right? And Karen was close friends with him and his wife. And if she thought that John O'Keefe was killed inside this house, wouldn't you go to his police officer friend that's not associated with these people and be like, you need to help me. You need to help me find the truth. But no, she cut off contact with everybody. And that's the last thing that you would do if there was a mysterious death. You'd be like, what happened to him? You'd be talking to everyone. But she cut off all communication with everybody. Like, it's just so obvious that she did it. And she didn't want to, like, say anything to anybody because she knew she did it. And I think, I don't know, that's the bottom line.
James Hamlet in chat asks if there's an ongoing investigation into the Norfolk County DA's office. And I'm going to say, well, we couldn't know. My guess is no, just because that may have been motivated and part of what motivated this investigation. But there's no reason to think there is. Let's put it that way. There's no more reason to think that the feds are investigating Norfolk County than they are Essex County or Plymouth County. There's no reason to think it. So they seem to now have open lines of communications between the feds and the Norfolk DA's office. At least they called the DA's office and told them that their investigation into the Karen Reed thing is completely over. So I don't know. That's just to answer James' question. I have no reason to think that. So do you think with Kohlberger, is there going to be a cult? So we're seeing the cult around Karen. We're seeing the cult around this Luigi guy, right? So is there going to be there's a little bit of a cult, even Turtle Boy, about Richard Allen, killed those two girls, Abby and Libby. Now they call him Richie. Is there going to be a cult about Kohlberger? I'm
sure there will be. I mean, I get comments on it all the time where people, and I'm not even posting anything recently, but people would just be like, Brian Kohlberger is 100% innocent. Anyone that doesn't see that is an idiot. I'm like, what are you talking about? There's a gag order. Like, I mean, from what we know from the probable cause, I mean, it's a lot. I mean, we don't know any of their argument, though. Like, their argument is just that he wasn't there, I guess, because they're saying alibi, he was jogging in a park. But
no witnesses to that, and he's jogging in the park at 4:00 in the morning.
Yeah, but his phone is off during the murders.
Right, his phone, and then he goes back to the very crime scene at 9:30 in the morning, before the police have even arrived, before the police have even been called. You know, yeah, that's there's a difference between reasonable doubt that a jury might find, between we and the public should say, all right, that's the guy, even if reasonable. And I don't think there's any reasonable doubt here, but I'm just saying it's a different kind of standard. Like I had no problem at the time. When OJ was convicted, I believed that he was guilty and that there might have been reasonable doubt because of police misconduct. Now, I didn't follow the case closely, so I'm probably, but that was my general feeling at the time,
Yeah, I mean, I didn't follow that either, but like from what I know, I mean, there was some police misconduct, I think, and then there wasn't a lot of like hard evidence though, like there is in this case. Like there was some blood, like a speck of blood from Ron Goldman, I think, in OJ's car. But like he left to the airport right after that, so there was no time for him to like really clean up. So like that was, I mean, that's reasonable doubt. I mean, there's no reason for Ron Goldman's blood to be in OJ's car, but it was just such a small amount that.
Looks like we're going right to sidebar.
Oh my God.
Ted Daniel is saying that breaking, Fox 25 investigates first reported, and 4 other reporters also confirmed that the federal investigation of Karen Reed is over. I guess you don't count me, Ted, but I reported it 2 days before you. That's all right. I'm invisible to Ted. All right, I can get over it.
I have to drop off this, but I'm going to be listening, and I'm going to pop on later.
Thank you very much, Matt. Good. This is Matt from Boundless Millennial. Thanks for being here. Appreciate it as always, man.
All right. Thank you.
All right, guys. So a lot of these sidebars are just things that can't be discussed in open court, grand jury testimony. Not sure what else, but we'll give Ted credit for reporting it, and because it was important, especially since he seems to have been pandering to Karen for most of this. So, you would think that him reporting this might have had some weight with them, but it didn't. They started attacking Ted right away, even though he's basically one of them. They started attacking him, and that's how they do it. So, but again, the most important thing is the relief that the witnesses and the investigators are getting after being subjected to this for a year and a half. And Bill McIntyre reported too. Actually, Bill, you gave me the freedom to think I could go public with it. I wanted to see something on Twitter before I could do it. And when I saw that, I was like, hey, Bill's going with this. You think I could go public? But I reached out to the important people involved that could be hurt by this, and I wanted to make sure that they were all comfortable with it. So got the green light from them too. But yes, Bill was the first to report it on Twitter, as far as I know, Bill McIntyre. I was plugging into Twitter just to see if somebody was reporting it. I'm not comparing Karen to Luigi. I'm just saying there are similarities where people turn a murderer into a hero. Look, and it's not new. Like Bonnie and Clyde, right? They were, bank robbers back then that were turned into heroes, and kind of understand it too, because it seemed like they were daring and the banks were hated. This was during the Great Depression. So that's, it's understandable how they were. And even further back, going into the age of the gunslingers, little small pulp journals and stuff like that were able to turn the gunslingers into heroes. And, but this is definitely different, here where you're turning now Brian Kohlberger. This in the evidence seems to, so let's use alleged. She's not convicted. Allegedly killed those 4 kids, but the evidence is pretty compelling to me. Where I'd be shocked if anything came out that showed he didn't do it. I'd be truly shocked. So, but I'm open to any new evidence that comes out on anything as it comes out, But yeah, so we're seeing people, Richard Allen in Delphi, his own words put him at that bridge just minutes before the girls arrived with no other witnesses. His own words. And that bridge was a dead end. So it was a perfect trap. And he knew that because he'd spent a lot of time at that trail. He lived a mile away. So he knew once kids started down that bridge and it's 700 feet long, they were going to go to the end of the bridge and then turn around and have to come back. And so he had them trapped. But his own words put him there. And not only did it put him there, but he said he didn't see them, which is impossible. So, I mean, there was other evidence against him. But that alone is enough where it's not reasonable for someone in the public to think he's actually factually innocent. Well, it's crazy. How much of this is just the need to have an entertaining narrative? I mean, this is, what is true crime, right? I don't think it was, when I was growing up, there was such a thing as the expression true crime. I believe it was just called crime. So true crime, to me, kind of implies that you have these cases that almost play like a mystery novel. They have that same kind of like a thriller. They have those same elements, except they're true. But you have to remember the main purpose of it does seem to be entertainment. So court is, again, just to remind me that I'm connected to the court TV feed, and it's about 30 seconds to maybe 45 seconds behind, maybe even as much as a minute. But I'm sticking with it because the audio is better. So they'll be starting up in a few seconds. I can see on the other feed. It's not like we're watching a sporting game where someone hits a home run and you want to know exactly when it happened. So if I wasn't telling you, you wouldn't know that I'm behind by a few seconds. So it's, I don't know why Court TV does that, but they're behind, but they have good audio. For some reason, the Law and Crime Network, theirs is on time, but their audio is like half of what the Court TV audio is. But we'll be going on in a second, and it'll be David Yannetti continuing. All right, here we go.
All right, Mr. Yannetti, go right ahead.
Thank you, Your Honor, and thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in...
We did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge. And I'm
Just
thanking...
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement? And what was the date that you all found out about what Mr. Brennan just announced?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. So just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Any follow-ups?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it when the reality is now that case is closed.
If I may just briefly respond, Judge. I'd like the court to take particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. We need to give them a minute. The parties have any problem with hearing that motion now? It is a
No, Your Honor, I think it's very
motion.
brief.
All right, so I need 1 minute, Mr. Jackson.
Of course.
Jimmy, I have to figure out which one. The ones from this morning, the new ones. I have to check. All right, so you're both prepared to argue this motion, right? The motion and the opposition?
I'm so sorry. Your Honor.
So if both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I, speak with counsel? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G-I-A-M, P-I-E-T-R-O, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos, and then about another 15 actual videos. I basically...
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was...
Yeah, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court. I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sally Port garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue.
I have not looked at them, Attorney Riley did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although they do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting that, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sally Port video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today. And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Misty and Eddie after 5:30 one night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Laura?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Oh, of course, yes, I believe we will, for sure.
How does that schedule work?
It works for the Commonwealth.
Right. I need to ask this little one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just
Thank
go do that
Thank you.
and not have to come back here.
Yeah.
And I'm trying to consolidate this now so you can leave in half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I'll be able to do it. That's fine.
All right, so where do we stand on the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that. Obviously, we gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the Canon PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion was just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
think we'll file a written response.
Okay.
So we're gonna be a couple of days.
Okay.
And we have motions on maybe Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite a bit of our time.
Right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back Monday.
We can do that now.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions in 1 week on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss though, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need something, right? I need to know by Thursday. It doesn't have to be a complete report, an outline even, would the Commonwealth be satisfied with an outline? You know what the points are?
An outline of what you are.
Of what Ms. Little says, how this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I'll want to supplement it very quickly thereafter. I have to decide this and put something right. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute, Ms. Little? Your Honor, given what Mr. Lee just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede.
This, what?
The motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hangup is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right. Ms. Little doesn't look through.
Right. The key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
I'll defer to the court. I know it's more complications with the defense and travel will be available when
So I think we did log off today and tomorrow, with the understanding that the defense team would not be here until sometime 11 o'clock or later. What about Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on Friday.
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. and Mr. Little will handle that. It's our motion anyway.
I greatly want to accommodate the defense as we have the entire time I've been here, but we have trial prep to do as well. The more court hearing days we have hours of conversation, the more time we can meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hear that tomorrow as well?
Very well.
Okay, and then we'll just finish up everything tomorrow.
Very well.
All right. All right, and then you won't have to be here Friday, but the motions in limine are all filed. It also involves filling out a final trial conference report. So
Understood.
you need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're gonna have a full hearing. I believe it's the 18th, and the motions in limine.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both, trying to get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday?
For the,
Motions in limine.
the Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday. Yeah, they all on Friday.
Reciprocal discovery is due Thursday. We want that to happen. Motions in limine, I believe, are due Friday.
Ms. Little, would you like the weekend for all those motions in limine?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motions in limine to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard
A Daughtert motion for?
yet. Dr. Wolf is a neurologist. So there's
Oh,
one
I
additional.
was thinking the archivist.
No, Your Honor, it's the neurologist of the Commonwealth. Wolf without an E, WOLF. That was filed, 2 weeks ago, I think.
I have not seen that.
Okay. I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their limited motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right. If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just don't contact the clerk's office.
Sure. Okay.
Anything else for today then?
Not for the defense, Your Honor. Thank you.
So I'm gonna give you all a, why don't you clear up all the things I'll be up to.
What's the call, guys, please?
I don't know if you guys were paying attention to the closed captions a couple minutes ago, but it said something about the the feds and a smoothie in the courthouse. I swear to God, I don't know exactly what it said, but it actually did say that. Closed captions are obviously pretty limited on this there. I don't think there's going to be any smoothies in the federal courthouse, but I could be wrong. All right. This to me showed how dirty Josh Levy's administration was at the U.S. Attorney's Office. So on January 30th of this year, now Josh was gone at that point. He had been gone a week, but his assistants were still there and are still there now. And they informed the prosecution and the defense, they informed the parties that the federal investigation was ongoing. But then literally a couple weeks later, on February 19th, so on February 18th, Attorney Little said in court that the federal investigation is ongoing. So now they finally get a response from the U.S. Attorney where the new U.S. Attorney, Leah Foley, is finally comfortable in her position, and she reaches out to the Norfolk County DAs and also to the Mass State Police to say that that's it, and to the Canton Police to say that the federal investigation is over. So did the actual federal investigation end sometime between January 30th and February 19th? No, of course not. That's absurd. So why was the U.S. Attorney's Office still saying on January 30th that the investigation was ongoing when it clearly was not? Dirty. It's the only possible explanation. Some combination of trying to help the defense or trying to avoid scrutiny of something that is embarrassing to the role you've played up to that point. So those people, Josh Levy's, the two lawyers, not going to say their names, that helped him, and possibly other people, but at least those two assistant U.S. attorneys that helped him on this case are presumably still there and still trying to help Karen and still trying to cover up. Now, cover up their own wrongdoing. All right, let me take that out. Unless you guys want to watch that, you can let me know. I can put the volume back on for a second, see if
secondary opposition and said, we want to take that statement away and we want to change it to, we did not reimburse or pay for this investigation, because they did in fact hire them, because they paid for their time. And that's, as you know, in an expert, that's the first Achilles heel that any attorney is going to go after. That is, you're being paid by these people to give this testimony, so therefore there's a natural bias for you to please them. So I would like to perhaps probe at that change in their opposition. And also, I would like to hear from these witnesses, because there's this vape as to where and when the discussion of the reimbursements took place. I don't think these people came here from out of state and gave their testimony without that expectation. And I think the defense is trying to say that was the case.
Right. And the prosecution pointed out that there were documented dates, that those experts documented for their work prior to getting on the stand. And so, I think the perfect point to end on, Rick, for anyone who has never worked in the legal system and doesn't understand, it's fine for experts to be paid. That is not the problem. That is not the issue. The issue is not disclosing it and making a different representation that they were wholly independent. So, and also the time the check comes in, that's another, I keep saying, well, it came after the fact. Yeah, well, that's generally when goods are paid for, after the services or the goods are rendered. That's standard. So at any rate, we'll see what happens this morning. 9 o'clock is the scheduled time. Rick Grundy, I know we need to let you get off to court and handle your own cases. Thank you for making time for us and weighing in on this one for us.
Okay, so that was actually recorded before the hearing. So there's not a new update on that. I can go and see what's going on Court TV if they're doing any live analysis. But as I was saying,
the trial and error, why did OJ win trailers, starts now.
Today, my office filed murder charges against OJ Simpson.
All right, we'll just cut that out. As I was saying, to me, this is evidence of wrongdoing. When I'm going to say wrongdoing, but I don't necessarily mean illegalities. At the very least, it's evidence of unethical behavior by the U.S. Attorney's Office that it requires a change in administration to get them to pursue the truth and do the honest thing here and reveal that there's no basis for continuing this investigation. Boy, there must be some tension in that office. But it seems that new U.S. Attorney, U.S. Leah Foley, is a person of quality, of integrity, and courage. That's seemingly what we're seeing here, right? So it's encouraging. It's very encouraging that on January 30th, even though Josh Levy had been gone for a week, the U.S. Attorney's Office was still reporting that the investigation into Karen Reed was ongoing. But then on February 19th, they reached out after seeing that being exploited in court to say, no, it's not. And I mean, this was always the right thing to do, because it took that. It's not just about justice for Karen anymore. It's about justice for the witnesses and the investigators that have been falsely accused here of being part of a conspiracy. And the feds, Josh Levy's office, utterly lacked the integrity to clean that up. They just did. I mean, at this point, they did. We'll never get the full story from their lips unless there's a whistleblower that comes out and explains it to us. But at this point, it's crystal clear that the investigation wrapped up a long time ago, and they kept it open just to avoid scrutiny and just so Karen's team could continue to go into court and say stuff like that. And so finally, Leah Foley, seeing that used on February 18th, said, enough. I'm putting my foot down. No more. And so she stood up, probably to her top assistants, who were probably Josh Levy's old henchmen, and had to stand up to them and say, no more. This is bullshit. So hopefully that continues. Sunlight is always the best disinfectant. Get to the truth. Now, did Josh Levy break any laws? I have no reason to think that he did. He's an elite attorney, but they hide under the cover of policy. You can always find some technical reason for keeping an investigation ongoing, which helps the defense. He knows it helps the defense. You don't think the U.S. attorney who reported on January 30th that the investigation was ongoing, you don't think that attorney, I think they listed her name as a woman, she didn't understand that Karen's defense team was going to use that, was going to exploit that? You don't think she understood that? Of course she did. You don't have to be a lawyer to understand that. Even a free Karen Reed person can understand that. So she knew that her reporting that as ongoing was going to be exploited by a murder defendant. She knew it. She did it anyways, or was told to do it. That, to me, is evidence of dirt, because there was no ongoing investigation at that time. They weren't looking into anything else. The federal grand jury had been ended a year ago. There's no reason to think that there was some stone left to turn over that they hadn't turned over. There's nothing. So they were just hiding behind that. And that's all. And that's how the feds work. And they've done it. Listen, I've seen this before in many other examples, whether it's the Whitey Bulger case or the investigation of Russian collusion. When they're caught doing something, they use tricks like that to avoid scrutiny. And am I saying that Josh Levy began his involvement trying to help Karen Reed? No, he's not an idiot. But at some point, somehow he was duped. Maybe he just looked into Karen's eyes and really believed her. Maybe he looked into David Yannity's eyes and really believed him. I don't know. There certainly doesn't seem to have been much evidence on which to predicate the federal investigation. But I do believe he was probably duped. But then he lacked the integrity to do the right thing and clean it up and protect those witnesses. There's all kinds of evidence for this. All kinds of evidence for this. I've been over it many times in the channel, but just briefly here, the U.S. attorney himself participated in the grilling of the witnesses in the federal grand jury. I have not been able to I've talked to judges, I've talked to former FBI, and I've talked to people that work for U.S. Attorney's Office. None of them could recall anything similar happening. Making matters worse, when he grilled the witnesses, he used a blow-up of TB Daily News, which he knew would terrify them. At that time, the mob was going after the witnesses, and those witnesses were due to appear before the federal grand jury, so they went to Josh Levy's office for help, for protection. They were ignored. And so he was certainly aware. Now he goes in there knowing that this mob has been created partly based on his investigation and just the presence of his investigation. And then he's going to bring TB Daily News as a blow-up display so that the witnesses can actually see it? Give me a break. Give me a break. He knew what he was doing. So I've talked to people that have known Josh Levy for many years, and they say he would never do anything underhanded. He did. He did. So there's an investigation that remains to be seen here to get to the bottom of what happened. And it's as Hank Brennan described it in the last hearing, it's murky. And we may never plumb the depths, truly. It's murky. But there is something improper there. And, the old expression, the cover-up is worse than the crime. There was a cover-up here. There is an ongoing cover-up here that hopefully Leah Foley is getting to the bottom of. But the cover-up doesn't involve the planting of evidence. The cover-up involves a defendant using the all-powerful federal government to aid her defense and to smear innocent people, to undermine the justice system in this state, the belief, the confidence that the citizens of this state have in that. Actually, all right. So we're going to be back in a moment. I wasn't sure. Hold on one second. The hearing is about to reboot. I may just be about scheduling, but all right, I'm going to go to the law and crime one, since that one is the only one still covering it. Thomas, I thought we were too, but it wasn't really clear the way the judge walked out there, so I'm not sure. They may just going to be discussed scheduling. I believe that's all it is. Unfortunately, the fan is not telling me right now. Let me try to get that psychic communication that we used to have with the fan during the trial. The fan does not know either. Oh, wow. So we'll see what goes on here, but I believe that there's no more discussion to be had on any motions, because next up will be tomorrow. They're going to go to the motions dismiss. They're going to wait. This will be an afternoon hearing. It'll be sometime after the appeal that's been taken to federal court by the defense. That will take place in the morning. It's the same appeal that the SJC already denied. So I am on law and crime. Well, this will be a way to test if the volume has improved from during the trial where it was bad. Maybe it'll be nice if the volume is good, because there's no delay on this one. I agree, Heather, that appeal is going nowhere with the feds. It's going nowhere. Ashley, thank you. You'll have to just kind of rewind to see it. I don't remember all of it, and I don't want to be too repetitive. Space Ninja, welcome aboard. Thank you. Our friend Rainey down in Washington, down in Florida, is watching. Case in Chief, he reminded me. Thank you. And we already played this. We already had this question earlier. All right. So just wanted to say thank you to everybody. So, we have some action here. Either it's coming on or it's going to go to something like the rainbows again. Well, we'll just wait and see. But I don't think there's any substantial continuation of any. I don't think there are any issues to be discussed today in court except for scheduling, unless I'm wrong. But tomorrow will be the motion to dismiss and the rebuttal by the state. I personally, we're gonna cover it. We'll stream it. I don't think it's all that interesting because I've read the motions, I've read the rebuttal, and it's all stuff that we've heard before. Live view, so not sure what that means. I think it might be done, but we'll leave it on just in case, and until they actually stop that feed. So the three bases for the motion to dismiss by the defense was, one, the irregularity with which the Sallyport videos have been released, first starting right before the trial, then some more this summer, some more in October, and some more in as late as the end of January. So they're going to say that there's some intentional aspect of that, whether it's by the prosecution or the Canton police or something like that. That's not going to go anywhere. If it was going to go somewhere, they wouldn't need to go to their second point, which was involved Jen McCabe, and she was with Kerry Robertson. They stopped by Officer Lank's house the day after John's death. So we're getting the thanks for watching. That might mean that it's done. I believe it is. It wasn't real clear the way the judge kind of walked out of there real quick like that. So, and then the third aspect of the motion to dismiss was this weird thing about Lieutenant Fanning somehow trying to, I don't know, do something. I don't know what, intimidate or something to do with the jurors, and something to do with the dismissal of that juror, which we know was a turtle rider. Now, we don't know exactly what the basis for dismissal was, and we probably never will know. We'll never know, at least officially from the court.
Same age
Okay.
as my dad. I'm not a math guy. 30 plus years older than me.
All right. Because that's jury information that's going to be protected. But I can tell you from multiple sources that she was misbehaving and certainly lying under oath, lying to get on that jury, going around that's saying that she was a turtle rider and she was going to acquit Karen. So I don't know if the defense wants to dig up that can of worms, but that's not going to go anywhere. All right. So I need to have lunch. So I'm just going to check quick and see if you guys have any questions about anything I might have missed, or if you just want to tell me to go F myself or something like that. Let me just look real quick, and then I'm going to go have lunch, and we'll see you tomorrow. Any questions do you guys have? This here is my completed Rubik's Cube, which, no, I did not complete during this session. I'm afraid to scramble it because I know I'll never be able to finish it. Abraham D-Turk, you're welcome, man. Doing the best we can. I still prefer night shows. My brain is not fully awake in the morning. I'm up early, but it just seems to take hours and multiple cups of coffee. Let's see. D said, one movie, find out if the prosecution is going to be sanctioned. Doesn't she have to rule on that before? I don't think look, it's, if you mean, is the prosecution going to be sanctioned? No, she's not going to be. No one is going to be sanctioned here. Not in any way that dismissed, not in any way that impacts the trial. I agree with Francesca's sentiment. We all just want the trial to start and then be done. Can lying to get on the jury be prosecuted? Yeah. And, I don't want to see anybody get in trouble, but in a way you need to do it to send a message before this trial to everybody else. And so any other prospective juror, that if you lie to get on this jury and say, look, we've already had people say in chat on Turtle Boy that they have been called for jury duty at that courthouse that day and that they are going to acquit Karen. So you already have people that are on the record that they're going to lie to get on that jury. So you need to send a message. But, I don't think that's going to happen, because I think the only time that this happens is if you have a bribe involved. And there's no bribe here. This doesn't involve bribes. It involves a cult. Barb asks what happened to the car data. We're going to see at trial. There was 8 gigabytes of new data. Whether any of that has any relevance or adds any new information, we'll see. I don't know. And we're not going to find out until trial. Hank Brennan is aware of all the risks here. You can tell. And he's going to be very careful. His office is a fortress. Nothing is leaking out, and nothing should. And that's the right way to do it. And I'm not saying that anything really leaked out of Lally's. It didn't. So. Dixie Doodles says this case is interesting in so many ways. So are you new to the case? You're correct. And, this is a unique case because of the federal involvement, because of the mob that stirred up in so many other ways. So you have a case, as Vinny has said on TV, which it's unusual, where the defendant has so much support. Why? What is it about Karen in this case that resonates with people so much in the public? What's up with Sean McDonough? Living his life. I don't know. Hopefully all is well. I really don't know. If I'm ever on Court TV, put the clip on the channel. Well, I don't think they would allow me to do that. So, not live. I could do a review of it on like another night, but I'm trying to avoid that too. I don't want them to in any way feel like I am pilfering their content. So, at the most I might play a clip or something, but I don't even think I've ever done that. I actually don't really like watching my performance afterwards, so I don't like the sound of my own voice. That's apparently there's reasons for that in the brain, that most people don't like the sounds of their own voice. So, prediction about the sanctions: there's not going to be any significant sanctions that are going to impact this trial. It's all going to be slap on the wrist stuff, maybe fines or something like that. But I don't, I think the judge made clear this morning from her attitude that, in her opening question, that you guys misrepresented the truth to us. It's not an excuse to say that one lawyer knew about it and the other lawyer didn't. No. But based on the way she was scheduling things, that she's not going to do anything that's going to disrupt this trial. So I believe, as I've been saying for a while, Court TV, unless it's changed, is to be tonight, tomorrow, and Friday at 8 with Nick, Joe, and Wayne Dennison. Same format as last time, where they want it to be more loose and it's kind of a free-for-all, but it's kind of an evolving thing because nobody wants to interrupt anybody else. Tom says some would say that his voice is his favorite sound. I'll second that. Yeah, I feel this is pretty ready for trial too. I mean, it should be, right? We already had a first trial. There's still some things they're trying to work at here. You know, they're trying to get that metadata, but can I get Joe Krauski on my show? I'd love to, but he is a lawyer, so he's very busy, and then he's called on court TV a lot. So 8 p.m., 8 p.m., 8 p.m. tonight, tomorrow, and Friday, unless I get notification of some change. They scheduled that last Friday. But no, yeah, Joe is great. I would have Joe on the channel anytime. And months ago he talked about it and said he would, but I may not be big enough for Joe. I'm just kidding. I love Joe. We'll usually be texting each other during the show too if we're on at the same time, just clowning around. "28 days." You're right, Francesca. You're welcome, Jen, and good to see you. I don't think it's 11 a.m. I'm not sure. I think it's going to be later than that because they can't do it until things wrap up at the federal hearing. And then they probably have to have lunch. So I would guess it's going to be, I think it's scheduled for 2 for tomorrow, but to give them time, they want the defense to contact the court as soon as it ends. So they'll try to get it on earlier. So we'll have to kind of be scheduled it by ear tomorrow. I think they might try to get it on as early as 1. We don't know if Alessi's going to be the one arguing for the defense tomorrow. It sounds like Alan Jackson is. But if it's Alessi, they're going to need another week. So Ms. Kara, you're welcome. Thank you for being here. Was it a good or bad day for Karen? Well, we did learn, finally, officially, that the feds have ended their investigation. Interestingly, as I just was talking earlier, we learned that January 3rd. So the new U.S. attorney took over about January 21st. So Josh Levy, who's led this investigation, left. But on January 30th, the feds informed the parties that the federal investigation was ongoing. And then, strangely, on February 19th, after seeing the defense team say this in court on the 18th, the new U.S. attorney reaches out or has somebody reach out to say, no, the investigation is over. And so I don't know if there's any lawyers listening to the show at the moment. And you can email if you're not comfortable posting in chat. But do you admit that that looks a little shady? Do you admit that it looks dirty? January 30th, it's ongoing, and now suddenly February 19th, it's not ongoing. So if somebody with more familiarity with the U.S. Attorney's Office can reach out to me, that would be great. I know you probably don't want to say anything in chat, so reach out to me by email. To me, that's dirty. And here's what it is. Need to get to the bottom of it. All right, guys. Thank you very much. And thank you, Matt from Boundless Millennial, being here. Please make sure you subscribe to his channel. He's doing a lot more live shows now, much more entertaining than me. So check out Boundless Millennial and Jen Coffindaffer's Breaking the Case with Jen Coffindaffer. So please check out those channels. And whatever time, this seems like it's still up in the air, whatever time this is going on Friday, we will be covering it, whether I'm here or not. So I do have a doctor's appointment in Boston. I have to be there at 11:30. So I would probably be available to cover this starting around 10:30. So, but Kate has already agreed to step in. So she can run Yellow Cottage Tales, and she will know how to bring in anybody else that's willing to join the panel. Matt, Jen. I think Jen said she'd be available. Maybe Daniel from Drunken Turkeys. Tuesday's a tough day for Daniel. So, all right, guys, thank you very much. And I'm sure, well, check me if you're interested in Court TV, check us out tonight at 8 o'clock. And otherwise, I will see you sometime soon on this channel.